is a good thing about that's a good thing about the condo and the HOA addendums, and they conform with state law. You can terminate even before you've gotten the package. So let's talk. Someone else mentioned the PICRA and the PICA. I think Manesh, you may have, or Nikki, you may have mentioned that. This was going to be on the quiz questions, but I'll throw it out there right now. There's the contract is contingent on the home inspection. Can the buyer terminate the contract without having first done the home inspection? Who has an opinion on that based on the contract?
No, they have to get the home inspection back. Why, like,
Okay, anybody think? I agree with you. I mean, it doesn't, if you look at the PICA, it doesn't come out and say that the buyer doesn't have the right to terminate if they, the other verbiage in the PICA leans in that direction. It implies that the buyer has to get an inspection done. And they can't just go walk through the property and say, oh, I don't like this. The buyer would be ordering a home inspection through a DPOR certified inspector. It's not even, them going in and deciding they don't like it. So I agree that you need to, if you don't want to end up in a big dispute, you will have to do your inspection before you can submit that release and termination under the PICA. I don't have a contract in front of me, so this, I'm going to have to go by memory. Say the buyer does the home inspection, submits a PICRA, and then the next day, before the seller has an opportunity to respond, the buyer says, oh, I found a better property. Let's withdraw that PICRA. Can the buyer do that? Can they withdraw the PICRA at that point and submit termination and get out of the contract?
Yes.
Anybody have any?
it was agreed upon, so.
As long as the PICRA is not signed in return, yes.
Let's see, does someone have a PICA and say that again?
I just think I would disagree because the buyers, once the PICRA is submitted, the sellers then have 5 days to respond and negotiate. And so within that 5 days, if the buyer were to rescind or send a termination within that 5 days, then the buyer would be in default because they've already submitted the PICRA.
Where does it say in the PICRA or the PICRA that they have to give the opportunity to respond? Where does it obligate them for that?
They got 5 days.
Well, I understand that they have 5 days to respond, but where does it say that the buyer has to wait for the response?
Someone send me the PICRA and I'll put it up here.
Yeah, thank you, Thomasina, because I can't
You're
get
welcome.
my one right now. Yeah, I
Everyone
think
should
it's
have, almost everyone in this room should have a PICRA in their email they can send me, so we should be able to get it up here pretty quick.
Okay, that sounds good. Thanks for that, because I asked that question without first pulling the document up. Unless they revised it with the July 1st revisions, I feel like it was unclear under, or if they could withdraw the PICRA and then submit a termination. Because before July 1, it said that the negotiation period was for making offers, withdrawing offers, counter offers. And I felt that that was not very clear. And I don't know whether or not Rain clarified that on the July 1 changes. So once we have the new PICRA up front, up on the screen, we'll be able to look at it, the new PICA. So let's table that and go on to the next question. Can you all hear me already? I think my internet is kind of messed up today, but let me know
Yeah,
if
we
you
can
can't
hear
hear
you
me.
fine. No, we can hear you fine.
Oh, good. All right, so the next scenario, what happens if the appraisal comes in low? Can the buyer walk away? Are there any conditions under which the buyer can't walk away? Who wants to throw anything out on that?
Yes, the buyer can walk away.
Okay, and now, does anyone want to counter that or qualify that?
What if the seller?
Depends on the loan type.
The buyer is in a contract
It
with the
depends.
understanding that be that value, buyer to buy that house, like they thought they were buying it at a particular value and it's not in there, so. They
Depends on
still
the,
have the right to walk away, even if the seller agrees to reduce.
except unless you're a conventional loan. At a
Okay.
conventional loan, the seller agrees to reduce, then the buyer is still.
Yeah, you all,
That's
yeah. You all have nailed it. It depends on the loan type. Exactly. So conventional, yes, if the seller submits an addendum, says they want to reduce the price, the buyer's locked in. FHA, VA, it doesn't matter if the buyer wants it. All right, you all are smart. Very good.
We have the picker,
kind
if
of-
you would like to do that now, I'm not sure.
Okay, so if you want to throw the Pika up there, we'll go
Pika
back
or
to
the
that
picker?
one right now.
You sent me both because that's
The
why you're teaching.
Pika,
All right, hold on 1 second, let me, hold on 1 second. Which one? That's the picker, so the other one should be the Pika. There we go, got the Pika.
okay, so let's scroll down to paragraph 2. Oh, I guess it's the second page, isn't it? Yeah.
Kind of hard to see.
Yeah, page 2, there we go. So if you look at the negotiation period there in paragraph 2, the party shall have 5 days after buyer's delivery of the proposed removal addendum to negotiate and agree upon the removal addendum. Then it says at any time during the negotiation period, buyer or seller may make, extend, alter offers and counter offers as desired to finalize the removal addendum. You know, that doesn't say that they can withdraw. If I were a litigation attorney, I think I could probably try to make some hay out of that if I were representing the buyer, saying, well, it's obvious that that they had the opportunity, but I don't think it's obvious. I think looking at that verbiage, I think the buyer is on thin ice to try to withdraw the PICRA the day after submission and then submit a release agreement. Now, that is my opinion, but because it's not clear, I don't think you're going to find any escrow agent giving the buyer back their earnest money deposit without a fully signed release under that circumstance if they try to withdraw the PICRA and submit a release agreement before the seller has had any chance to act on it.
Agreed.
Okay, very good. A couple of other, something less likely to ever happen, but if the seller fails to submit, for example, a lead-based paint addendum to the purchase agreement, or if the property is in an above 65 decibel noise zone and they don't have it properly disclosed as what zone it's in, and that doesn't happen these days. But if it did, those are grounds under which the buyer could terminate the contract for failure of receiving those disclosures. Finally, what if the seller can't clear the title? Say it turns out there's something missing, a judgment against a former owner, or a deed of trust in the name of the former owner, and the seller can't get it cleared up by the closing date. Does the contract expire? Can the buyer terminate it? Do the parties have to agree on a release? Which of those 3 do you all think is the correct answer? Does it automatically expire? Let's address that first.
They have 10 days to resolve it as per the contract.
Okay, now they have 10 days if nothing is filled in that blank, right, in paragraph 8. But if they fill in 1 day, then maybe it isn't a full 10, right? It depends on what's filled in there. Is that right, Nikki?
Correct.
Yes.
Yeah. So if say it hasn't been filled in and so it is 10 days, does the contract expire at the end of those 10 days?
Yes, it does.
It doesn't expire per se, it's just out of contract and neither party is fully obligated.
Who the heck was your broker and attorney all these years?
Yeah, I agree with you. I think it does have to be terminated. I don't think there's anything in that 8. If you study paragraph 8 of the RAIN contract, it says that a non-defaulting party can terminate the contract, but it doesn't say it just suddenly dies. There may be some REO contracts. Thankfully, we haven't seen REO contracts very much recently, but there's some REO contracts that might have different language. But the standard RAIN contract, yeah, at that point, a non-defaulting party can terminate. I do think it gets a little trickier when it's the seller who has the title defect and then they want to try to terminate it. I'm not sure that that works because they've agreed to deliver clear and marketable title to the property and now they can't for some reason. So I think only the buyer could terminate in that situation. But the buyer could by right terminate. The seller doesn't have to, agree. It can be terminated unilaterally. There are, and since I'm taking a lot of time, there are some reasons where the seller can terminate automatically. Can you think of any reasons where the seller can terminate automatically? I mean, the only thing that jumps to my mind is if the buyer's loan is not approved, it's, past the grace period in paragraph 8, I think the seller can terminate unilaterally at that point. Does anybody disagree with that? Yeah, so that's about the only situation I think of in the contract where it's 100% clear that the seller can terminate without the buyer consenting or being a party to that termination.
Yeah, I think the only thing with that is we'd have to see that they were not, we'd have to see from the loan officer that they didn't, that would be the only stipulation.
Right, that it wasn't something where the seller somehow contributed to the loan not being approved.
Right.
If the situation of the buyer not having loan approval and the buyer not wanting to terminate, if I'm the one holding the EMD, I really am going to prefer to see a release agreement. I'm not going to want to be the one to decide that the buyer did what they were supposed to do in pursuing the loan and making my own decision to release the EMD. And I do want to talk about the EMD release because
yes,
a lot of times people come to us and say, okay, the contract has been terminated. We want our EMD back. If a release is signed, great. We can immediately give back the EMD per the terms of the release. If a release hasn't been signed, whether it's us or somebody else who's holding their earnest money, we have a duty to verify that the party making the claim to the deposit is entitled to it clearly under the clear and explicit terms of the contract. And that's set forth in paragraph 5A if you're ever having a client giving you a hard time about it. And it may take a few days to verify. And if it's not clear cut, what we typically would do is send, or if somebody's objecting, we would send a notice out to the party who's not going to get the EMD and give them, say, a 15-day opportunity to object. And then we would, if they don't object, then if we're feeling like we're on good grounds, we'll go ahead and release it. If we're not sure we're on good grounds, then the other options that paragraph 5A gives to the, or is it 5B? Gives to 5B, gives to the escrow agent is to interplead it with the court, or one or the other parties could file a suit and ask for a court order directing me to disperse the deposit. If you get into that, it's just not economically worthwhile over a $500 deposit. It might be for a $5,000 deposit, but not for a $500. So we hate having money languish in our escrow account, but sometimes it does because of that very obstacle. There are some opportunities for termination where it's not immediate and automatic. For example, what happens if the, and this doesn't happen a lot under the contract these days because of the market being what it is. But what if the PICRA repairs, say the appraisal comes back saying you need a new roof, and that's more than 1% of the sales price? Can the seller just say, I'm not going to pay that and automatically terminate?
No, that would be negotiable. If the buyer agrees to it, then the contract is not terminated.
Yeah, I agree with that. There's a period of time in which the parties can negotiate over who would pay that excess amount. So I do think you have to play that has to play out. And I think the same thing applies on a low conventional appraisal. There needs to be some time to play out to see if the seller is going to agree to reduce the price before, in that case, the buyer could terminate. So yes, there's some things where there is a right to terminate, but it takes some time to work through it. And there are other things that are just simply fact driven. The fact that one party isn't ready to close on the closing date, there may be some facts that go into that where it's not automatic and you have to lay a case to be able to terminate. Sometimes you have to get your lawyer involved to write a demand letter and tell the other party if they don't perform by such and such a date, we're going to assume that they don't intend to perform and we're terminating and moving on. And hopefully you don't have to hire a lawyer to do that. So I think that's all I had. And I do feel like the questions I was going to do in a pop quiz, we've kind of covered as we've gone along. Thomasina, I know you had expressly asked for this topic to be addressed. Is there anything else that you had in mind that I've just completely missed?
No, I think you did good. The only thing I would add is, as she stated, I'm just going to reemphasize, a termination is not a release. So a termination is unilateral, and it doesn't always mean that the person is in the right. They can still be in breach of contract just because you unilaterally terminate. That would be something that you would want permission to terminate. You're going to want to go to Lucy and talk to her about it, or you can, talk to Susan and Austin. But you want to make sure that you're not putting your client in breach of contract by doing that. And a release, will release the money for sure, but a termination does not. So just make sure that you understand a termination is not a release. They're two different things.
And I think there's one question in the chat, Thomasina, that maybe we should answer. Shelley wrote, doesn't paragraph II under the PICRA justify the buyer termination during the negotiation period? Shelley, I think we addressed that, didn't we? Was there anything else you wanted to say about that? Guess not. She didn't.
So I'm sorry, I was trying to come off mute. So they're able to terminate, but does that mean that they will be able to get their EMD back as far as the release goes if they terminate during that period of negotiation before the PICRA is signed?
Well, I think they have to wait, honestly. I think. Go ahead, Thomasina.
Shelley, I was asking Shelley, is she saying the release is signed or not?
So maybe I'm getting them a little bit confused. So the release is not signed yet, but let's say the buyer sent the PICRA over, but it hasn't been executed yet. They can terminate during that period and still be able to get their EMD back, right? Or am I misunderstanding that?
I think what we had said is that because they've submitted, that I don't think it's clear in the PICA that the buyer can terminate during that 5-day negotiation period. I feel like the language is such that it's intended to make the buyer have to wait. Yes, they can negotiate back and forth with the seller, but I don't think they can completely turn on their heels, withdraw the PICRA and terminate once they have submitted a PICRA.
Can you pull it back up? I know you had read the paragraph I, but the one right below it is the one that may be causing a little bit of confusion for me.
Okay, let's take a look at it here.
PICRA or PICA? What do you want?
It was on the
PICA?
PICA, the one we were reading. Mm-hmm.
No. Hold on, let me go back to Sword.
And just to kind of get some more clarity, isn't it technically like day 7? Because like they have 5 days to negotiate, and they get a bonus day, and then on day 7.
On day 6, the buyer can unilaterally terminate after the day 6, and either party can unilaterally.
Correct. It's 5 days plus 24 hours.
Yeah.
Yes. So Shelley, let's see, I've got let me close the chat so I can look at the paragraph there with you. And I see, if you look at it talks about what they can do during the negotiation period, and that does not include the buyer being able to terminate. It says buyer or seller may make, extend, or alter offers or counter offers as desired to finalize the removal addendum. And I don't believe that language allows the buyer, once they've submitted a PICRA, to just say, we changed our mind. We're now withdrawing our PICRA and we are submitting a termination and release. I think once they submit it, they can do certain things within the negotiation period, but terminating is not one of them. So I'm sorry, I couldn't tell whose voice it
So
was.
paragraph I is what kind of seems like it's contradicting that. It says if the parties have not executed prior to the expiration of the negotiation period, the buyer shall have the option to terminate the agreement.
Yeah, but
Well,
the
but
first
you
one
have-
says the 5 days.
Yeah, you have to wait, Shelley, an additional 1 day after the negotiation period. So you've got the 5 days under little I, and then under little 2I, after that 5-day period, the buyer has 1 day to kind of stew on it. And then at that point, they can terminate, but they have to wait out that 5 days before they can do it.
Okay.
Yeah. Okay. Well, thanks for raising that question.
Yes, it's a good question, and people need to know that. It was really,
Yeah.
because this is the part right here that gets everybody, and they don't fully understand it. And it's not just our brokerage, it's everywhere. Like this is a huge portion of real estate that people get confused on.
Yeah, I kind of wish maybe Rain would make it a touch clearer, and I know they've been trying. But yeah, the fact that it still creates confusion. But we all need challenges, so.
Yes.
Any other questions? We
Yes.
have 5 days to go back and forth between the buyer and the seller, right? It's not each side gets 5 days.
No, it's 5 days total. Yeah.
That's right.
Yeah, that's a good clarification question.
Yeah, absolutely. And sometimes it's a little confusing because people think, okay, well, I had until October 13th to submit my PICRA, but I did it on October 10th. So now we've got 8 days, but you really don't. You have 5 days from when you actually submitted it, not from when you had to submit it. The seller has the 5 days in there. So.
Yeah, they're
All right.
wording
Well,
when they say prior to the expiration date. That's what kind of throws it a little bit, because you're saying prior to the expiration date. So that seems like you're saying before the 5 days is over. Depending on how you read it, it's kind of confusing.
Yeah. So within 1 day, when it says there on the third line of buyer shall have the option to terminate the agreement by delivering a termination to seller within 1 day following the expiration of the negotiation period. And then it says the additional day. I agree with you. What does the word within mean? Does it mean 1 day before? Does it mean 1 day after? But the fact that they've defined it as additional day means 1 day after. So yeah, actually, I'm sorry.
It's because of that comma that says negotiation period, comma, which means then the buyer shall. That's where it's confusing, Shelley. That comma is there, but that comma is there as a pause to continue to tell you what it is that you can do as far as the days of the expiration. And that's where the additional sentence comes in, and the period doesn't come in until after the parentheses of the additional day.
Yeah, good way to explain it. So the buyer, after the 5-day negotiation period, the buyer can terminate in that 1 day in between. The seller can't terminate until it's been 5 + 1. And I think I was being unclear what I said earlier about that. So the seller has to wait an additional day, but the buyer can terminate on day 6. The seller can't terminate until day 7, actually.
Right.
Do you agree with that, Thomasina?
Yes, that is correct. That's what I always say. You have the negotiation period of 5 days. Day 6 is the buyer, day 7 is the seller. And it's 5 days plus 24 hours. So they finally put in 1 day in there. They used to say 24 hours. So we used to always do the 24 hours, but now they finally did 1 day. But back in the day, it said 24 hours.
Mhm.
So
So you're
yes,
not trying to figure it, okay, I said
Yeah,
o'clock in the
yeah, it
afternoon.
used to say 24 hours. That's why I always say it because I'm so used to it. But they changed it last year. So they have on day 6, they can, day 7 is seller. Well, actually, day 7 is either one, not seller. It's either one. Day 7 is actually
True.
buyer or seller. I'm sorry, excuse me. Day 7 is
Right.
either buyer.
Right, good point. Shelley, did we clarify or is it even more
Yes.
confusing?
No, I'm good. I'm just super technical with words, so it kind of was confusing, but thank you.
You're smart to be super technical with words in the situation like this. Yes.
Agreed.
Okay.
Anyone have any other questions either here or online or Susan?
Hey, Thomasina, I don't know if you got the email that I sent to you yesterday that my compliance team sent us. It had to do with like a random Facebook post that somebody got in trouble, a real estate agent or a realtor got in trouble because they didn't put not a hyphen, but a apostrophe or something on an S. And now they're getting like sued for slander or something like that. So I just wanted to, since we have a legal expert, I guess, on here, just figured I'd mention that. It just randomly, I sent that email to you yesterday. Like I said, yeah, there you go. Boom. Anyway, that's all for that. And one other quick thing while I had the mic. So we have a chalet on Sunday for Wine Fest. I know I told Thomasina about it, but if anybody is going to the Wine Fest in Norfolk Town Point Park on Sunday, feel free to stop by our tent or our chalet. It's open. Our chalet is open to friends, family, business associates, and everything in between. So, like I said, any questions, feel free to email me or Thomasina has my contact information as well. But if you just walk around the chalets long enough, you'll find us. You might see a doppelganger of me. We've got a 6-foot Courtney and a 6-foot Cragen cutout that'll be in attendance. So, but yeah, that's all.
No, that's really good, Craig. I'm glad you're doing that because Susan's reading this, I can tell, and she needed a few minutes. I just scrolled down and said she's still reading it. Craig, and can you put your information in the chat if you don't mind? And then I'll pull that up on the screen. I'm letting Susan read this because I am interested. I did have it yesterday, that's why I saved it. I was actually going to go over it when Susan was off, but good catch, Craig, and just having legal counsel take a look at it to give us the opinion. Susan, if you need me to move down, let me know.
Give me just a second here.
Yeah, I know.
I mean, it gets down to the law of defamation and whether or not something you say about someone else injures them in their trade or business. And I think what the point of this is that if it was one employee that if the guy was saying, well, you failed to pay all of your employees whatever superannuation is, and I don't know what that is other than some sort of extra commission scale, maybe based on overall volume. Or if he's just saying you didn't pay me mine, or are you saying you have a pattern of not paying it to anyone, based on the fact that employee apostrophe S would have meant one person, but employees with no apostrophe would have meant the whole company. And that would definitely be injurious overall in the broker's trade or business. So, but it's just to show that sometimes it does matter. As Shelley was saying, the grammar sometimes does matter. So.
Yeah.
Absolutely. Yeah. I shared this with my 13-year-old, because he's going through grammar and all that. And I'm just like, we're adults and we forget to put apostrophes and just random grammar type things in there. And to me, I would think that would be, you'd have to have a really good lawyer, I guess, to get you out of that one. But it just seems a little bit extreme. But they even made the joke on the email, don't drink in Facebook, or drink in Twitter, So it's just, I don't know. I thought it was kind of comical, but at the same time, I thought it was super pertinent for you to share with your agents as well. That's why I sent it to you.
I appreciate it. I really do.
Yeah.
Susan, anything else or anything else for Susan?
I don't think so. I don't think I have anything else. Sandra, do you have anything else from our firm that you wanted to say to the Keller Williams agents? Anything that's come up on a closing, or good to go for now?
No, I've been super lucky recently. I haven't had any issues.
Excellent. Or you all are so squared away, going well.
I know what we need to say, Susan. We do closings across the water now.
Yes, that's right. That's right.
Yes,
Um,
at no additional charge. We have a traveling notary. Is that the correct terminology, Susan?
Right. It won't be one of the lawyers in our office, but we have worked with a mobile notary on the peninsula, at least Austin has, and likes her. And we've worked something out where your client, the buyer, will not have to pay for it. It's going to be paid through the joint venture title agency. So yes, thank you, Thomasina, for remembering that.
Yeah, I saw Holly's name and that's what reminded me. So I had to make sure.
It's not my fault, I just business over there.
Yeah, it is not her fault, her business, but I am thankful for the business over there, and I'm thankful that we can now do this. If you have any closing across, we always were still doing them. It's just they were traveling over here. So now they don't have to travel. Our notary will go to them, and there's no additional charge for that to the client. So you're able to do
Yes.
that now.
And if there's something complicated or if you think it's a first time buyer and it would be better, we'll call in one of us will call in during that appointment and sort of do an introductory talk with them. So we're still available. We just won't physically, it's kind of prohibitive for one of the attorneys from our office, Virginia Beach, to go to the peninsula for just one closing. So that's why we're doing it this way, but we are available to help during closing. Yeah.
Where would the closing be at?
You can
Their
choose.
home or-
Yeah, you
or
can choose.
gather?
Yeah, you can choose. We have Gather over there, which is really nice that you can use, or it could be at their house, it could be Starbucks, it could be anywhere. Yeah, go ahead.
My question is the mobile notary going to actually explain the docs, or is it going to be a sign here, sign here, sign here?
I'd have to say, I don't know. It's not a lawyer, so they're not allowed to interpret legal documents. Some of the mobile notaries are paralegals and they have done closings. They've worked for title and escrow companies. Austin actually has talked with this person and Ashley in my office has worked with her. I have not. So I don't know. And that's a good question. We'll find that out and we'll let you know about that. So you know whether it's important to have one of us on the phone during the closing or not.
Either way, we'll get.
Yeah.
Yeah, let me know, Susan, send me an email if you talk to Austin.
Okay.
And then we'll know. Anyone have any other questions? Susan, let me check the chat just to make sure. Oh, wait, I lost the chat. Okay. Okay, all right, yeah. All right, I think that's it, Susan. Thank you so much. As always, it was a pleasure.
Thank you all. It's great. It's great working with you. All right. We love working with you guys. Okay, we'll see you later.
We love you guys.